All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh and give their attention to the court now sitting. Please be seated. Good morning and welcome to the Kansas Supreme Court. Welcome both those who are in the courtroom today as well as those who might be watching us through our live stream. At this time, I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 o'clock docket.
Thank you, Your Honor. May it please the court. First case on the 9 a.m. docket for Wednesday, October 30th, 2024 is appeal number 125156, State of Kansas versus Jason M. Gleason Sr., Reno County, briefs both sides.
Hey, please the court. My name is Andrew Davidson. I represent the state of Kansas. Present, ready for argument.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm hearing this morning on behalf of Jason Gleason, and I'm ready for argument.
Second case is appeal number 126950 in the matter of the wrongful conviction of Shamarki Warsame, Johnson County, briefs both sides.
Good morning. I'm Michael Crabb. I represent the claimant appellant Shamarki Warsame. I'm present and ready for argument. Also with me today is my co-counsel Daniel Meany.
May it please the court. Special Assistant Solicitor General Curtis Wired, present and ready for argument. I'm also joined today by the Solicitor General Anthony Powell. Thank you.
Your Honor, that concludes our 9 a.m. docket.
All right, thank you. Thank you, Mr. Schema. I'm going to take just a moment for those who may not be familiar with the court and how the court works. I think most of those in the courtroom probably are, but we may have some online who are not. We receive cases that have been heard primarily from the district courts or the trial courts of Kansas. When that happens, we are presented with the records of the proceedings that happened in that lower court. In addition, we have the written arguments from the attorneys. They set out the issues, the claims of errors that they believe happened at the lower court, and in response to those arguments as to why no error occurred. We have received those writings, both the record and the briefs, and reviewed them thoroughly, as well as done and our own research about the cases. We have made notes to help us digest all of that information that we do receive. So at times you may see us looking at our notes. Some of us keep them on computers, some of us have paper. Please know that when we are doing that, we are not distracted, but we are looking really at specifics to help us understand the attorney's arguments or to help us focus on something that we may want to have a discussion with the attorney about. So with that, I would now ask the attorneys in case number 126156, State of Kansas versus Jason Gleason, to please come forward. Mr. Davidson, take your time in getting settled, but once you do, you're welcome. Move towards the lectern.
May it please the court, Andrew Davidson, representing the state of Kansas. I would like to reserve 5 minutes of rebuttal time.
5 minutes is reserved.
Your honors, this case happened during a short jury trial. The state produced evidence in this case. We began our case with our opening statements. And during the opening statements, the state focused its primary argument that this was in fact a physical contact theory of the case. At the end of the closing arguments, I did mention that there was some injury sustained to Austin Spencer to kind of put that idea out there because it was going to come up in this trial. At the end of my opening statement, the defense gave theirs. And during the course of their opening statement, they began talking about the injuries and what Mr. Gleason did and whether or not he was the proximate cause of those injuries, which opened some questions up for this case. The evidence was produced. The state called numerous witnesses and the lead investigator who testified that Mr. Spencer was working in the chow hall, and during the course of his duty there, Mr. Gleason walked up to him with his fists and began striking at Mr. Spencer, after which a chase was on, and Mr. Spencer, unfortunately, when he was going to tackle him, Mr. Gleason, he flew over the pile and struck his head. Prior to that, Mr. Carpenter, I believe was the witness, testified that there was video of this incident. I played the video for the jury. There was evidence that showed that Mr. Spencer was wearing glasses and that the glasses were knocked off his face, which the state would show can only happen through physical contact. There was some question about the injuries to Mr. Spencer's forehead because when Mr. Spencer took the stand, he did not remember any of this event because of those injuries. Because this was a very short incident that maybe took less than a minute for it to happen, it sort of, everything just kind of played together. Mr. Spencer could not remember anything, even when I attempted to have him refresh his recollection using a report he had written. He said, no, that would not help me. So he is not a very good recollection witness, but the state then closed the case. And in a first part of the state's closing argument, the state focused entirely on the physical contact aspects of this case. I believe that the argument was that he was wearing glasses, that the glasses were knocked off his face through the punch that was made. It didn't land well, but it was good enough to knock his glasses off and make physical contact and cause a slight, very minor injury to the bridge of his nose, which Officer Carpenter had testified to earlier. And I believe that then I closed my case, or ended my first part of my closing argument, and defense got up and the defense started arguing about a lot of things, including some of the evidence that he had admitted earlier at trial, which showed that Mr. Gleason didn't cause the injuries because he was being tackled when Mr. Spencer flew over the top of his head, and that that he wasn't responsible for those. And the state, in a rebuttal, maybe I got a little overexcited, and I said, well, he did cause those injuries, because without him behaving like that, then he wouldn't have had to have done what he did. But I said, that's not what's important. What you have to determine is whether or not physical contact happened earlier in this case.
Did you associate, well, but did the prosecution at any time in this case associate the table injury as being evidence of the physical contact?
I don't know if it was. No, I don't think that I did produce that type of argument. I think what I was
I mean,
arguing.
basically what I'm getting at is, because he hit his head on the table, that proves there was physical contact of the fist to the face.
I don't think that was my argument, and including in the rebuttal portion of my closing argument, where I stated, there was an injury, and one of the other officers testified that the indentation in Mr. Spencer's forehead mimicked the round seat of the table. But then I tried to differentiate that injury, which was very severe, from the one that was minor on the bridge of his nose, which I was arguing was evidence that it was a very trivial little nick on his nose, which I was arguing that came from when he got punched earlier and the physical contact occurred. And that's what my argument was. And so I, upon reading the Court of Appeals decision, disagree that there was prosecutorial error on that matter. And that it definitely cumulatively did not affect the jury verdict. This case happened on video, and you can watch Mr. Gleason just march straight up to this individual who was just standing there and take a sucker punch at him. And, then he takes off running. And the jury had the opportunity to look at that charge of physical contact. And they also had an opportunity to look at an alternative means, or not an alternative, but like a lesser included of attempted battery. And the jury rejected the attempted battery charge. There was argument both sides about whether or not this actually was physical contact, and the jury was satisfied based on the video evidence that was produced in this case that he did cause physical contact with him. There was an error in the jury instructions, but I believe the Court of Appeals was correct in their decision there, where they stated the error was harmless, because you can't watch that video and not look at what Mr. Gleason did as behaving anything other than rude, angry, or insulting. So if that instruction was given, during the course of the case, the verdict would not have changed.
Was the head injury used as an explanation when Spencer testified that he couldn't recall?
I believe that Austin Spencer did testify that he had severe mental problems after this, including memory loss.
As a result of the injury he sustained from hitting the table?
Yes, and that's why that was relevant.
Right.
He didn't know anything.
Was there an objection to that testimony?
No, and I don't think that the defense wanted to exclude that evidence because they didn't file any motions for limine or anything like that. But it was part of this whole entirety of the case. So then this court needs to determine whether or not the error on the jury instruction combined with the prosecutorial statements, which I don't believe were error, caused a cumulative violation of Mr. Gleason's rights to a fair jury trial. But the state would argue that this case had overwhelming evidence, and including in the Court of Appeals decision, the Court of Appeals found when concerning itself with the instruction and whether or not physical contact had occurred, that there was overwhelming evidence that the jury could be satisfied that was the result, that the physical contact did occur. And then later they said, but it wasn't so overwhelming when coupled with prosecutorial statements. But I disagree with that. I think that the evidence was overwhelming, and regardless of what the state's argument was or defense's argument, the jury made the right decision here in finding Mr. Gleason guilty. Are there any other questions? Because I'm almost out of time.
Just curious.
You have given us several reasons why the evidence about hitting the table was relevant, which are legitimate reasons, is loss of memory and otherwise. But in your opening statement, you talk about that injury without any explanation of how it fits into the case.
Yeah, it was offhand.
Does that
I
cause
do
does that cause a problem? I mean,
But I
it
didn't.
almost as if you are trying to excite the jury about that injury more than you are to give it a reason why it's going to be talked about.
I'm sorry for interrupting you during your question. I think when I said that, I was just trying to give a preview as to there's going to be some evidence about this injury. I didn't try to tie it in. I didn't say that that's the reason why you need to find him guilty, but it was going to come up. And so that's why I brought it up. It does. It did bring that up a little bit, but then the defense, they went right into it and talked about whether or not he caused it, and that's what they have to decide. And I think when I focused my rebuttal on those things, it was to directly respond to counsel's argument. Justice Wall, did you have a question?
Yeah, I was just curious your position on harmless error, the jury section 5 argument that was made. On the one hand, it does seem like when you don't object to an instruction that omits an element of the offense and raise that as a jury trial issue, it's an attempt to circumvent our framework. On the other hand, there have been other state Supreme Courts with similar section 5 language that has taken that position that when that instructional error implicates the inviolate right to a jury trial, that harmless error analysis is not appropriate. And I'm just curious how you respond to that Herald decision, the Mississippi Supreme Court's.
The way I respond is that this court has ruled numerous times in the past that that argument is not appropriate. I think there was some argument in 2015 regarding Herald, but as recently as last month, this court issued an opinion that harmless error is still what the standard is on instructional errors.
With an omitted element? Does that make it different, though? I guess is my question, is that did he really have a full invocation of his jury trial right when he doesn't have a jury determination on an essential element?
I think he did, Your Honor. He had the right in this case. And if that instruction was given, regardless of whether or not that rude, angry, or insulting manner happened or was instructed, it was there. And that's why I think the harmless error standard is appropriate in this case. Are there any other questions, Your Honors? Thank you.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Jason Gleason. My intent or hope is I don't have a lot of commentary on the state's argument with regard to the procedural error. I mean, I think the court has asked some of the questions and some of the things that I would have highlighted. It was interesting to me as I was reviewing the case getting ready for argument that I wonder if there wasn't some sort of confusion, even when you look at the requested instructions in this case from the parties. Right? The parties were requesting instructions that had to do with causing bodily harm. And so it seems like there was some confusion about that. So I'm certain.
I want to make sure you agree, because I didn't see anything, but just nail this down. Do you agree that the state never tried to say that the head injury with the table was proof of physical contact?
No, that was not their theory.
So, and would you also agree that it was relevant to mention the head injury on the table, particularly when Mr. Spencer's testifying? Because there was no objection, to be sure.
Yeah, I
So,
think.
It seems like there's two anchors here on a continuum for us to buy the argument that there's prosecutorial error. And it's just we have to talk about it. They didn't try to associate it with the physical contact, but somehow in between there's an error that occurs, and I don't understand that.
So I think probably it's relevant, maybe for the purpose of explaining Mr. Spencer's testimony or lack of testimony. Maybe it's relevant in that regard. But the purpose of that testimony then is for that. It's not to prove it's not to prove battery, because that's not relevant. It's certainly not relevant to prove on the merits the battery. And I think that's where the confusion
You're
is.
saying there's some kind of implicit notion that the head injury would be evidence of the physical contact?
Yes.
And did the defense ever ask for some kind of limiting instruction or something to indicate that, we got to talk about it, but it doesn't go to this purpose?
The defense didn't ask for a limiting instruction, although I think that the purpose of the defense argument, the closing argument that the prosecutor is asserting opened the door for them in the rebuttal was to do that, was trying to say, look, we know he had these injuries. This is terrible, but it's not what we're talking about today. But then the state says, you know what? He did cause all those injuries and did not limit the argument to this is only relevant to you. If the state had gotten up a rebuttal and said, you know what? We agree with defense that these injuries are terrible, but you shouldn't consider them for purposes of whether you're figuring out whether there was physical contact, that would have been fine. But that's not what the state did. So again, for the reasons the Chief Justice noted, the state opened, is there a link between them? The state opened the opening statement was, you're going to see these injuries when he hit the table, and then we're going to ask you to find that he's guilty of battery. So we think that the Court of Appeals decision was reasonable on this, and we would ask you to affirm it.
Well, I am having a little trouble here with just the logical extension. You get hit in the head, and then you and someone else chase the person. And as a result of that chase, you're in tackling the perpetrator, you fall and hit your head. Why isn't that all just part of this case? And the injuries are connected to the initial battery, aren't they?
So if he had been charged with causing bodily harm, then I think we would have an interesting discussion about causation. And the Court of Appeals certainly had that discussion and said, we don't think there would be a causal link there. But I think we could have that interesting discussion then, Justice. But that's not what he was charged with.
I understand.
There is no causal link between the injury caused when Mr. Spencer hit his head on the table and causing, and that's your answer to your question, Justice Breyer. There's no link between that, but there was no limitation given on that. And in fact, the prosecutor's opening statement and rebuttal argument specifically referenced that he did cause that without any limitation. I'll leave it there. I do want to spend time talking about the state constitutional issue in this case.
Let me ask you on that. The word inviolate is used a few times in the Kansas Constitution. Whatever definition we give it here, does that need to apply both to, what is it, section 11 and section 15?
I don't know the references in those, so I'll.
11's first, you know, like 11's the free speech,
Okay,
free press, you know, shall be inviolate.
Yeah.
So do we have to give that the meaning to inviolate needs to be the same in section 11 as it would be in your section 5?
certainly my answer is yes. Not knowing what those other things say, my answer is still yes, because I think the language is clear. What does inviolate mean? I think it means not violated. I don't think there's a reasonable interpretation of that language that says what inviolate means is violated, but it doesn't matter.
On that point, we have case law that says that what inviolate means is that the right to a jury trial is preserved as it existed when the Constitution was adopted. Do you agree or disagree with that?
I believe that's what your cases have said, yes.
But do you agree with that as a statement of law? Should that be the interpretation of inviolate? Or should we change the interpretation?
I think I think the core is the plain language of the Constitution prevails. I mean, I don't think there's any inconsistency between the plain language in this case and the way that Section 5 has been interpreted. So I don't.
The reason it's important is because if that's what the word means, then we have to inquire what was the state of the law when the Constitution was adopted. And if that's not what the word means, then who cares?
Yeah. Certainly.
My obvious follow-up is going to be, what was the state of?
Yeah. And so I certainly think the language of the Constitution controls. I think the state constitution controls this body. And so if it's clear, I mean, I suppose it's an interesting question of like, well, what if you decide today, the Kansas Supreme Court in 1868 or sometime didn't construe it correctly under the plain language of the document? Can you today say, we think that was wrong today? Can you say that?
Well, that's more complicated than I think my question is intended to be. I guess I haven't heard you answer my first question, which is, do you think that an interpretive lens on Section 5 that simply says we preserve the jury trial right as it existed when the Constitution was adopted, do you think that's wrong or somehow inadequate?
If it would lead to a construction of the Constitution that's not consistent with its plain language, I would find it not to be correct. I think the Constitution has to
That's
control.
just circular. I mean, that.
No, I don't think it is. I think
Well,
it recognizes.
If the plain language answer is, it means what it meant when we adopted the Constitution. I mean, I am asking you the plain language question. Do you disagree that that's what the word inviolate plainly means?
I think the word inviolate means not violated.
Yeah, but you have to have a standard. You can't just say not violated because you only can measure violations against the standard. And the reason that this court has historically chosen the standard as what the law was at the time the Constitution was adopted is because that makes some measure of sense. I'm asking for the standard. How do you tell whether it's violated? What is the standard against which you measure?
Yeah, I mean, certainly as far as like the components of the right to jury trial and this court's understanding of what those components of a right to jury trial are in civil cases or in criminal cases under Section 5. As I understand it, the interpretive rules that you use would say we want to look at what we understood that the components of it to be, right? For example, in a criminal case, how many jurors do you have to have? Do you have unanimity? Those kind of things, that there are components about that. And then the interpretive lens that you would use, that you describe, would be like, well, what did we understand that to be then? I think I can accept that that's the test that you've used.
So just final, really quickly, do you know of any case law from at the time our Constitution was adopted or prior, obviously in common law across the country. That said, the failure to instruct on an element is a failure of the jury trial right. Is there any case that says that?
I haven't, I mean, I certainly have assumed that,
Yeah, your brief doesn't cite it.
yeah, and the state hasn't
agree.
responded and I mean, the state has not suggested anything otherwise. The Court of Appeals in this case did not suggest
Right, but
anything
if the
otherwise.
standard we look to is what the law was at the time the Constitution was adopted, that just seems pretty important to me.
Yeah.
Do you agree?
I certainly accept that the elements of the crime that it is a state constitutional violation that in a criminal case, if the jury does not find all the elements of the crime. And that's historically true. I mean,
But you
and
can't cite
if
a
we need
case.
more briefing on that, certainly court, your honor, you could order us to brief that more to see if I'm shocked to find, but you're right, we haven't engaged that question very much.
Another way to frame the question is, did courts in the 1860s conduct a harmless error review?
Well, I don't know if that's the case or not, but I mean, because I think that gets to the other question then. If they did, even if they did that, then is it appropriate? Was it appropriate in light of the words of the Constitution? So I am certainly working on the assumption, and like I say, your honor, we could brief this more if you disagree with this assumption or question this assumption, that it is a state constitutional right in a criminal case that the jury finds the elements of the crime beyond a reasonable doubt. That's an assumption I'm making. And that in this case, the jury did not find all the elements of the crime beyond a reasonable doubt. They couldn't because they weren't asked to. And so the question in this case, was the Section 5 right to jury trial violated? I think the answer is yes. And I think under the Constitution then, your job is done.
Would you say a judge cannot direct a verdict in a criminal case?
That's absolutely right. In fact, I was reading this case, I was reading the Court of Appeals decision, getting ready for this, and we had a sufficiency issue in this case. You didn't grant review on that, right? And so, we were doing, but the end of that decision is, and I've got 100 of these, right? Because we raised sufficiency issues, and the end of the Court of Appeals decision on that point was, this looks like counsel's thinly veiled request to have us re-examine the evidence, right? And we've seen a lot of cases. Sometimes that's fair criticism of me, sometimes it's not. But the point of that was, look, juries make decisions about facts. Judges give deference to jury decisions. That's the rule. That's the purpose or the underlying value of that statement. And to the extent that that's true, the problem here is you don't have that underlying jury verdict, that finding on which to give deference. In fact, if you find and apply a harmless error test in this case, you are doing nothing but substituting your judgment for that of a jury's. There is no jury finding in this case that any physical contact was done in a rude, angry, insulting manner in this case. There is no jury finding that. And if you would apply a harmless error test in this case, it can be nothing other than you substituting your judgment for that of the jury. And that's what the Constitution does not permit.
Yet in the context of a directed verdict, and then on the civil side, in the context of motions for summary judgment, for example, we understand, or the law has long recognized, that if facts are uncontroverted, they can be dealt with as a matter of law. And so your argument would be that cannot stand.
That in a criminal case, that cannot stand.
Why? Section 5 is a umbrella provision.
Yeah, and perhaps it goes back to Justice Stiegel's question. I mean, assuming a historic understanding that Kansas has never allowed a directed verdict in a criminal case. I'm not aware of that, although I haven't studied that question in detail. And certainly to the extent that it did, I would argue you shouldn't acknowledge that. Now, if that's true, then that was wrong when it was decided, and you should overrule it today. If you believe under our state constitution, under Section 5, that a district court can direct a verdict in a criminal case, I would ask you to overrule that, because it's.
Don't we have situations where they have the judge has not sent at least an A count or a portion of a case to a jury, or directed verdict in favor of a defendant, saying there's just not enough evidence here?
Oh, sure. Yeah,
What's the difference in that?
Yeah, I mean, I'm not aware of or any sort of application of the state having a right to a jury trial, if the right to a jury trial belongs to the defendant.
That section 5's not, that is the wording of, section 10,
Yeah.
but it's
And-
not the wording of section 5.
And also we have federal constitution. So even if we were lived in a world where the state does have some rights under section 5, the federal constitution certainly says trial judges shouldn't send cases when there's insufficient evidence.
I'm just trying to understand the impact of what you're proposing here, or what you're advocating for. And that would be that any omission of an element in a criminal case, the jury doesn't consider, and therefore it violates section 5's inviolate right to a jury trial. Would that be true in our neater type of cases where the omitted element is the age, let's say an age factor, where it's clearly in front of the jury? Let's say they don't prove the defendant's age, but in his testimony or her testimony, he says he's 35 years old. Those kinds of cases where we said, yes, that's subject to harmless error analysis, and the jury couldn't have decided anything else. Would that be implicated here too? Those kinds of situations?
Your Honor, I'm out of time. Can I answer the justice's question?
You may.
Yes, Your Honor.
Yeah.
I mean, that's exactly what we're
I figured
arguing.
that was your answer.
That in that case, the hypothetical you've given me, did the jury find all the elements, assuming
Well,
that
they
those
couldn't have,
facts that
because
you're talking about are elements of the crime?
Right.
Did the jury find those elements of the crime? No. Then the jury trial right was violated. And you can't go, here's the thing.
And
I'll
that was
close
the
with
argument
this.
on those cases.
I'll close with this.
Yeah.
I mean, again, I've got a lot of cases. We could find 100 cases that say, look, defendants aren't entitled to perfect trials. They're entitled to fair trials, right? Comes out of harmless error. We see this when we apply harmless error a lot, that there are some little errors that happen, and that's why we have a harmless error rule. I understand the policy behind it. You're not entitled to a perfect trial, but under our constitution, under our state constitution, you're absolutely entitled to a jury trial. And if there's a violation, the appellate court should be done under our state constitution.
I have one other question. Okay, so based on what you're saying, you're saying that it's based on section 5. So all the federal decisions, neither included, those are irrelevant because in section 5, the word inviolate is used. I mean, everything is focused on that word. True?
I don't know, I want to say everything, but it's largely, yes. I
Okay.
mean, and that's what the Herald Court recognized, right? That the Herald Court had applied neither before. And under the 6th Amendment said that, recognizing that the United States Supreme Court has not found that the 6th Amendment right to jury trial shall be inviolate. They haven't apparently found that. But the Mississippi Supreme Court and the Washington Supreme Court, which I followed up with additional authority, have found that where the state constitution says it's inviolate, what does that mean? It means not violated. In neither, is the right to jury trial violated? Yeah, it's just you find it's harmless. There's still a violation. Our state constitution says that's not acceptable, and we would ask you to follow that state
But on
constitution.
that, but that saying that, using that to say, okay, was the jury trial right violated? How does that preclude harmless error? It doesn't say, I mean, if the word inviolate means violated, I mean, just like you said, leaving out that part of the instruction, it was violated. But what part of the Constitution says that you can't analyze it for harmless error? Because as Justice Biles says, the word inviolate is used, is it section 11, the
11,
free
15.
press? Yeah. But we hold in those cases that that there are exceptions.
That it can be violated.
Right.
Again, I haven't reviewed this in the context of other sections, but this is certainly the reasoning of the court in Harrell and Requenco, that under the state constitution that inviolate means not violated, and violated but harmless is still violated. The only solution, if the trial right has been, the jury trial right has been violated, is to give the person a jury trial. That's the only remedy. That's our argument.
Thank you.
That's all I have, Your Honor. Thank
All
you.
right, thank you. Mr. Davidson, you reserve 5 minutes.
Believe that I covered most of my argument against counsel's argument in my first portion, but I believe that the harmless error standard should stand.
Do you have any response to my line of questions?
Can you go over that again?
Well, do you have anything to add about the state of the law on jury trials when our Constitution was adopted?
I do not. So I don't have anything further, Your Honors. Thank you.
Thank you. Thank both counsel for your arguments in this matter this morning. The court will take this case under advisement. Again, by way of brief explanation, what I mean by that is that later today, the court will conference this case and at least begin conferencing that case after we have completed the discussions and reached preliminary decisions about the course of analysis and the outcome. A justice will be assigned to draft an opinion that will be reviewed by all the justices who are participating in the case. And that review will continue until we reach a final decision. That may result in additional discussions along the way in person, may also result in additional opinions being written by different individuals that decide to take a different course of analysis or reach a different outcome. Once that all is finalized, the decision will then be filed with Mr. Shima's office, the clerk of the court. At the same time, a news release will be issued, making it public that the decision has been reached, and among other places, you will be able to find that decision in its full original form on kscourts.org, our court website. I note often that this is one of the areas where we attempt to have full transparency in our decision-making and the analysis that we use, something that is not required of the other two branches of government, but is something that we take pride in and value highly as the judiciary. So with that, thank you, counsel, for your arguments this morning. I will now call case number 126950 in the matter of the wrongful conviction of Shamarki Warsame. Mr. Crab?
Good morning. May it please the court. My name is Michael Crab. Excuse me. My name is Michael Crab. I represent the claimant appellant Shamarki Warsame. Appearing alongside me is my co-counsel Daniel Meany, who assisted with the briefs. May I reserve 3 minutes for rebuttal?
3 minutes is granted. Thank you.
Thank you. Mr. Warsame was overcharged and overpunished for his misdemeanor crimes. He served 564 days in prison for felony convictions that the state later admitted that it could not defend on appeal due to insufficient evidence of guilt. The trial court below erred by arbitrarily disregarding undisputed evidence that Mr. Warsame had no intent to defraud the two theft victims, Mr. Landry and Mr. Lofquist. The wrongful conviction statute was designed to not only compensate people who are wrongly incarcerated by the state, but also to rein in and to discourage prosecutorial overreach, just like this case. The trial court's judgment should be reversed for that reason. I want to provide just a very brief background on some of the key facts before we dive into the law. In January of 2018, Mr. Warsame's friends stole the contents of 2 open gym lockers. Later, Mr. Warsame used credit cards that he found within that stolen property to purchase gift cards at Target. He was caught and charged with theft and criminal use of financial cards, both misdemeanors. He was also charged with 2 counts of felony identity theft. He was convicted on those counts and sentenced to 12 months concurrent on the misdemeanors, which he had already served by the time of his conviction. Additionally, he was sentenced to 44 months consecutive on the 2 felonies. Mr. Warsame appealed those convictions. And after his brief was on file, the assistant district attorney who was assigned to the appeal agreed to jointly move to vacate the convictions without so much as even filing a brief.
It sounds to me like from that factual recitation that he wasn't necessarily overcharged. They just identified the wrong victim in the complaint.
That's one way to look at it, and that's the way the state argued it. But the important thing to remember is that it's not so much the victim, it's about elements of the crime. And the elements of the identity theft crime require that the state identify the person who was defrauded by the misuse of the personally identifying information. That's one of the elements of the crime. And the state could not prove, did not have sufficient evidence to prove that Mr. Warsame had the intent to defraud Mr. Landry and Mr. Lofquist. Going beyond that, it's not even clear under Kansas law whether some other entities, such as Target or Security Bank in this case, could even be victims of identity theft. This court held in State versus Euler in 2021 that business entities or anyone that's not a natural person cannot be a victim of identity theft. So that's the key thing to remember there. These convictions for Mr. Warsame were not overturned due to Fourth Amendment violations or improper evidence or speedy trial violation, ineffective assistance of counsel, any other technical procedural reason. The convictions were overturned due to insufficient evidence of guilt.
But insufficient evidence is not the same as actual innocence, is it?
That's correct. There is a legal distinction there, but
And don't you have to get to actual innocence under our recent case law?
right. So under this court's recent ruling in Doles, that was the holding, that the claimant must show by a preponderance of the evidence that the conviction was overturned because he didn't commit the crime for which he was charged. That's true.
And yeah, just how do you overcome that hurdle?
Yes. So I would submit to the court that in this case, the fact that there is insufficient evidence of guilt, the state admits that was the reason to vacate the convictions, that is enough to get you to the preponderance of the evidence standard, that the reason that the convictions were overturned or vacated was due to the fact that he didn't commit the crime that he was charged with. And I would submit to the court.
You think that alone meets your burden under preponderance of the evidence?
I do, Your Honor. That coupled with the.
Can you flesh that out for me? I mean,
certainly
it's not intuitive. It's not intuitively landing for me.
Right. Okay. So here's the way that I look at it, and this is what I would submit to the court. There is almost no case in which this court or the Court of Appeals, if it were to overturn, vacate, reverse a conviction, would come out and say that the reason for that is due to innocence or because the person did not commit the crime. At most, what the court will say is that there's insufficient evidence of guilt. Likewise, when the prosecution dismisses charges or elects not to refile charges, they never make a statement coming out and saying that's due to the fact that the person didn't commit the crime. No, if they make a statement at all, they will say it's because there's insufficient evidence of guilt.
Well, we know
What about
from
Lamont McIntyre?
Yeah.
I'm sorry?
What about Lamont McIntyre?
What about him?
Oh, well, okay, so the prosecutor came out and said he's actually innocent.
Okay. There are rare cases. I'll give you that. There are rare cases where, a person is exonerated by DNA evidence or something of the sort. Those are exceedingly rare cases.
Those are the cases that exist in the legislative history,
Right.
which provide the impetus for the statute in the first place.
That's true. That does appear in the legislative history. But I would submit to the court that is an exceedingly narrow interpretation of the statute.
Well, don't you think that's what the legislature intended it to be, extremely narrow?
No, I don't.
Can you point to something in the legislative history that would lead us to believe that their intent was to make it broad?
Well, I don't think necessarily the intent was to make it broad. I think the intent is clear in the language of the statute. When you have a case where a person was convicted of a crime that he or she did not commit and they served time for that crime, they should be eligible for compensation, even if they were guilty of some other crime, as in this case. Mr. Warsame admits that he was guilty of those misdemeanor crimes. He served his time. He served 12 months.
Just under the facts that both parties agree to in this case, make the argument that he was not guilty of identity theft. I'm struggling with that.
What he was guilty of was outright theft. There was no intent to deceive or to trick Mr. Landry or Mr. Lofquist, who
But
are
there
the
was
victims
an
of the crime.
intent to deceive or trick some other entity, correct?
I assume you mean Target or Security Bank or some other entity. I suppose you could make that argument to stretch, but
Well,
again,
how isn't that argument just sort of prima facie obvious from the face of the admitted facts?
because as this court has held, business entities cannot be victims of identity theft. Only
Well,
other human beings can. And in this
But
case,
there's a difference between who is the victim and who was defrauded. I mean, the entity towards which the intent to defraud is directed. In other words, you steal a credit card, the victim is the owner of the credit card and the owner of the identity that's attached to the credit card. But the intent to defraud is focused towards the merchant who the card is used with. I mean, what's wrong with that?
well, what's wrong with that is that that's not the case that was tried in the court below, in the criminal court. That's not the crime that was charged.
I understand that, but don't you have to prove that that didn't happen?
No, what you have to prove is that he did not commit the crime for which he was charged. And the crime for which he was charged was identity theft against John Lofquist and Mr. Landry with intent to defraud those two individuals.
Is that consistent with our case law, which, especially under the subpart C, that seems to say that as long as it's the crime of I mean, not the specific victims or the to wit, let's just describe it maybe as anything that we would say to wit in the charging document, but rather the elements of the crime. That, and here, one of those elements is that you obtain or transfer or use, personal identifying information to defraud that person or another. And so why aren't those broad elements as stated in the statute fall within the facts of this case?
Because what subsection C says, the plain language of the statute, is that the claimant did not commit the crime or crimes for which the claimant was convicted. And in order to analyze that, you've got to look at the elements of the crime as charged. And Judge Vano in the court below correctly ruled that way, exactly that way. He said, we're not looking at large, a claimant doesn't have to prove that he is innocent of any crime and every crime. What the statute says is that a claimant must prove that he is innocent or that he did not commit the crime for which he was convicted. And in this case, he was convicted of a crime that he didn't commit, i.e., he was convicted of using personal identifying information of those two gentlemen with an intent to defraud those two gentlemen.
And I think maybe we're speaking past each other because I think you're still talking about because of the way the victims were named in the charging document, not because of the elements of the crime, that there couldn't be under these facts if those two names had not been included, but rather just the statement of that they defrauded a person or anyone else. Wouldn't he have been guilty of that crime?
I don't know, Your Honor. I don't know. And the reason we don't know is because he wasn't charged that way. That wasn't the crime that he was charged with. And his burden is not to prove that he is innocent of any crime that he could have been charged with. His burden under the statute is to prove that he was innocent of the crime for which he was convicted. And I'm sorry.
You're saying not that what I'm focused upon the elements, period, as stated in the statute. And you're focused on the charging document. Is that the way we should look at it, to look at the charging document versus the elements?
Yes, because Your Honor, I think they're one and the same. The charging document sets out the elements of the crime and the prosecution has to prove each element beyond a reasonable doubt.
Theory of proving that.
No, I'm sorry.
It sets out the state's theory of proving those elements.
Well, it defines what the elements are. And in this case, the element of the crime for which he was convicted was an intent to defraud Mr. Landry and Mr. Lofquist, which the state later agreed there's insufficient evidence to prove that because he didn't commit that crime. He had no intent. That's the undisputed evidence in the civil case below. There was no intent to deceive Mark Landry and John Lofquist.
So Spangler, our decision Spangler is wrong because there we were talking about different degrees of murder.
No, Spangler is easily distinguishable. Spangler refers to actually subsection D, I believe, about the own conduct point here. Spangler, That's right. So Spengler was convicted of second-degree murder. It was reversed due to ineffective assistance of counsel. Then he was convicted of involuntary manslaughter. He served 4.5 years beyond his sentence and sought compensation. This court found that that's not possible in that case because you look at his own conduct. His own conduct in that case was he got a gun, confronted a man, and shot him to death with that gun. Those elements were present in both crimes, both murder and involuntary manslaughter. And so what this court said about that is that because the elements, here it is, a claimant like Spengler who stands convicted of a lesser included offense based on the same charge as a previous conviction is not eligible to seek relief. Here, felony or misdemeanor use of a financial card is not a lesser included offense of identity theft. This court clearly held in State versus Euler that there are two different crimes, two different sets of elements. One's not a lesser included offense of the other. And so Spengler is not at issue here. It's distinguishable from.
But the question remains whether the conduct caused these charges to be filed. And so I understand maybe factually it's different than Spengler, but does subsection D still ring true? Given that the underlying conduct, and the dismissal, at least from the record, appears to be based on maybe a charging mistake. And I understand your other arguments about whether there are alternative theories of liability even available, but subsection D is more how we've interpreted that to focus on the conduct that precipitated those charges.
May I answer? Mr. Warsame's own conduct brought about his conviction for the misdemeanors of theft and misuse of a financial card. That is true. His own conduct did not bring about his conviction for felony identity theft because he did not commit those crimes. The state later admitted that it had insufficient evidence to convict on those crimes and let the appeal go. So while it's true that he doesn't have perfectly clean hands, he did commit a crime and he did serve his time, his 12 months for those misdemeanor crimes. It's important not to overexpand that own conduct language in the statute because it becomes a slippery slope. What if, for the sake of argument, there was a murder that occurred at that same target later that day, and Mr. Warsame was picked up not only for misusing a financial card, but also for that murder? Later on, that conviction is reversed. Could the state say, well, if you hadn't been in Target using someone else's credit card, you wouldn't have been convicted for murder? You see how the slippery slope begins, and you can roll it on further from that. So in this case, I'm comfortable arguing that Mr. Warsame's own conduct did not bring about his conviction for identity theft, for a crime he didn't commit. At most, his own conduct brought about his conviction on the misdemeanors for which he served his time. Thank you.
Chief Justice, may it please the court. My name is Curtis Wired and I represent the state of Kansas in this matter. There are three clear avenues to affirming the district court. And I think the cleanest avenue is actually the one that Justice Wall, you finished off there on questioning. It's to apply this court's holding in Spengler and find that Warsame's own conduct in voluntarily taking credit cards that he knew were stolen into Target to purchase gift cards caused or brought about his conviction. In Spengler, you held that those underlying criminal acts can serve as the own conduct in C1D if they are both the cause in fact and legal causation of the claimant's conviction. Just as in that case where taking an AR-15 and shooting somebody was the cause in fact and was entirely foreseeable result, foreseeable result was being convicted of some degree of murder, using someone's credit card that they knew was stolen to purchase items, it's entirely foreseeable to say that that person is going to be convicted of identity theft. So I don't think the court has to get, there are thornier questions on the other cases where you talk about the specific crime, things of that nature, but perhaps the easiest way to dispose of this case is to apply Spengler to the facts.
And what about the argument that maybe in terms of foreseeability, your opposing counsel, I think, is arguing that there's just, as a matter of law, not conduct that could have supported a felony identity theft conviction here? How do you respond to that?
I guess I don't really understand that point there.
That a corporation can't be the victim of identity theft?
So I'm not too familiar with the fact that whether a corporation can be the victim of, I have to admit, I'm not entirely certain of that. I actually think that our position has been throughout this civil case that he was guilty as charged. And in the alternative, and that's what the district court held, was that he wasn't sure why the district attorney decided to reverse this or to vacate this conviction. I think, and I guess that would move me into my second point here, that the court could hold that the district court did not arbitrarily disregard any evidence when it found that Warsame did not prove he did not commit identity theft. Here, the identity theft statute states that Mr. Warsame had to have obtained or possessed personal identifying information of another person, here Landry or Lofquist, if we're looking at crimes as charged, with the intent to defraud that person to receive any benefit. Now, elsewhere in the criminal code, there's a definition for intent to defraud, which is an intent to deceive another person and induce the person in reliance on the deception to assume, create, transfer, alter, or terminate a right, obligation, or power.
Well, that's the point, is that he was trying to trick Target. He wasn't trying to trick the owners of the credit card. And I use the word trick as a stand-in for fraud, right? That's what he's representing himself as someone he's not,
Well, there's the intent.
in order to obtain a benefit, i.e. gift cards.
The intent to defraud language appears in KSA 21-6107, but the intent to defraud, this inducement, is in a different section.
Well, maybe I shouldn't do this, but leaving aside the statutory niceties,
Right.
this is what happened. He took the cards, went to Target. He's tricking Target. He's lying to Target, but the case was not charged that way. That's my understanding of what happened.
Yeah, it wasn't charged that way.
And because it wasn't charged that way, the district attorney agreed to jointly move to vacate the conviction.
Just to be clear, the district attorney admitted at trial, in the civil trial, that not that he was innocent, actually innocent, that he thought the case was mischarged. Those are two
Right.
entirely different concepts, and your case law requires actual innocence.
So that leads to my follow-up question, which is beyond the mere fact of the joint motion to vacate the convictions, was there any additional evidence presented in the civil action below with respect to actual innocence?
No.
Let me ask you this, in the statute that defines identity theft, 21-6107, subsection A1-2, obtaining, possessing, using personal identifying information belong or issued to another person with the intent to, and let's not talk about subsection 1, which is defraud, but with the intent to misrepresent that person in order to subject that person to economic or bodily harm. Does it fit that definition?
No, I believe it was charged under A1, so, but I think, just shooting from the hip here on that, I think it could fit that definition, but honestly, I would have to give that some more thought, Your Honor. I can't give you a definite answer.
Okay, but if it was charged under A1 and as, is he actually innocent of violating with the crime? Okay, so do you agree with your opposing counsel that it must be the charged crime and not the statutory elements, as the chief was asking?
No, I disagree with that. I think it has to be the elements of the crime as they're stated in the statute. So
And what support do you have for that?
that's our textualist argument, that if you look at C1C, there it says crime for which the claimant was convicted. The phrase that they emphasize, for which the claimant was convicted, simply, in our opinion, signifies the crime of conviction, i.e.
Okay.
the crime that precedes it.
Right.
And I think
Okay.
that interpretation best accords with your case law in Doles, where you recently stated that you went straight to the legislative history and said that it clearly indicates, as you mentioned earlier, Your Honor, about Lamont McIntyre, that these are cases that are limited to where there's evidence of actual innocence. The person did not do it. So in this case, to say while a perceived charging error is why the person's conviction was reversed.
I'm sorry to interrupt, but just in other words, I take your argument to be that, is it Warsame? Warsame has the burden of proof to demonstrate by a preponderance of the evidence that he did not commit identity theft.
Yes. Whether that's
You agree with
against
that?
yes, and whether that's against Target or the cardholders.
It doesn't matter. It just, he did not commit identity theft
Correct.
under A1.
Correct. That's the burden he has to carry. And here,
We went under A1.
And I understood that's the subsection he was charged under.
correct, correct.
So it is limited by the statutory subsection.
Oh, is it?
As
That's not what I
in terms of
understood
the,
you, sorry.
well, that's what I guess that's what I'm asking. Is it limited by the statutory subsection that's chosen? Which is still an elements test,
Right.
as opposed to, as the chief was suggesting,
Of any possible
sort of
variation.
two-wit
Right.
add-ons.
Well, I think it refers to the statutory elements that were charged, but it's not, it doesn't incorporate, I think their position is that it incorporates the charging documents and the jury instructions for every case. I don't think that it goes that far. I think it just identifies the elements. You have to prove
The
that you understand
elements
the elements.
of the subsection that was charged?
Right.
Okay, you see, okay.
And here, Warsame clearly intended to deceive the cardholders by inducing, even if we use that statutory definition of intent to defraud, which may or may not apply. But if you look at that, induce as a plain definition of causing them to assume an obligation to pay for their gift cards. And this is what the district court's, the crux of its decision was, is that it makes sense that when you charge something to a credit card, that you're necessarily saying that the people, the cardholders are going to pay for that item, albeit at a later date. So
Okay, an intention to deceive another person and to induce that other person in reliance on the deception. And then what are you saying? To assume a credit card debt?
to induce the person to, and then the statute says to assume, create, transfer. And
Right.
So they induce the person, i.e. they cause the person to assume a debt.
To assume a right or an obligation? Okay, to assume
To
an
assume the
obligation.
obligation, which is the debt.
Oh, okay.
Because he knows the credit card's going to be charged back against the person who he's pretending to be.
Correct. And that's the district court's reasoning. It makes perfect sense, I think, to me. And I cited a case from the Court of Appeals, State v. Granger, that makes this almost identical facts where an individual stole a credit card from an individual and took it to Walmart, purchased items. That person was convicted of identity theft of listing both the card holder and the store. And the Court of Appeals, looking at it from a multiplicity standpoint, said, well, you can be guilty of one or the other, but you can't be guilty of both because it's the same acts. So I think that at the end of the day, it's the same here. He was guilty of identity theft of Landry or Lofquist or Target, just can't be both.
Can I ask you some questions about actual innocence and the role that plays under the statute? It seems to me that the statute contemplates that if a conviction is reversed on appeal and then it goes back and it's retried and the defendant is found not guilty, they are entitled to compensation. That's one way to recover under the statute.
Yeah, I would say depending on.
And a finding of not guilty is not a finding of actual innocence, correct?
Yeah, so it would depend on the particular reason of not guilty.
And so in the situation where a defendant is simply not retried, you're not suggesting as a matter of law that you need the prosecutor to admit actual innocence in order to prove it, that you could just rely on the testimony of the defendant, for example. And if a prosecutor simply says, I don't think I've got enough evidence here to win this case, so I'm not even going to retry it, but there's other evidence of actual innocence in the civil case, you're not suggesting that the prosecutor's declarations alone control whether there is causation.
No, I think in cases like that, which are not the case here, the claimant could, and I think this is the point that was made at the end of Dole's, was the claimants can use the civil discovery process to dig in to find the actual reason for the conviction going away and not coming back. If there is evidence that can be uncovered of actual innocence, I don't think that wouldn't preclude recovery here.
Right. It's a question for the finder of fact to resolve potentially controverted facts.
Correct.
Okay.
So finally, the last clear avenue I think this court can go down to resolve this case, which we've kind of touched on already, is its decision in Doles, which held that and hold that Warsame has failed to show that his identity theft conviction was reversed and vacated because he was actually innocent. He has not presented any evidence there. The evidence at trial was from the district attorney that had the charging document listed Target as the victim, then he would not have agreed to vacate the charges. This is a case where he believed, in my opinion, incorrectly, but he believed that Mr. Warsame was charged incorrectly. Yes, unless there are any further questions, I'll just, are there any further questions? I'd ask that this court affirm the district court. Thank you.
Thank you. Mr. Crabbe, you reserve 3 minutes.
Because it came up during the appellee's argument, I want to point out again for the court that this court has expressly held that non-human persons cannot be the victim of identity theft. That's State versus Euler.
State versus what?
Euler, E-U-L-E-R. And I don't have the site, but it's from 2021. And I can find the site later if the court wishes.
Do you agree there's a difference between a victim and a third party who was defrauded?
Yes, I do. There is a difference, but again, that is, and that's not a technicality, right? That's an element of the identity theft statute that must be pleaded, charged, and proved, and was not in this case. And it's telling that the prosecution agreed to the vacation of this conviction after he had only served about 1.5 years of a almost 4-year sentence, and then elected not to refile those charges.
Would you agree that in the civil case below, the only evidence that you put on that your client was actually innocent was the reversal and the vacating of the criminal convictions themselves? Did you put any other evidence?
There was the testimony of Mr. Warsame himself, which, the trial court didn't place a lot of value in, but there was also the testimony of Mr. Minahan, who was the district attorney, and there was the testimony of Mr. Call, who was the appellate defender. Both gentlemen testified that they agreed to the vacation of the conviction because there was insufficient evidence of guilt. Now, whether you want to couch that as a charging mistake or what have you, I would submit to this court that that's significant. There's no such thing as a charging mistake.
Well, that could mean that the state simply can't prove one element beyond a reasonable doubt.
Right.
That doesn't prove innocence.
Well, I would submit, though, that in the civil case, of course, Mr. Warsame's burden is only by preponderance of the evidence. And he did prove in the civil case below that it is more likely than not that he didn't commit the crime that he was convicted of and charged with. And the evidence of that is that those two gentlemen, Mr. Minahan and Mr. Call, agreed to the vacation of those charges, and that the charges were never refiled. That is enough to infer and to get us past that 51% preponderance of the evidence standard. So, Your Honor, unless there are other questions, which I'm happy to answer, I would ask this court to reverse the decision below.
No question?
All right.
Thank you, counsel. Thank you to both counsel for your arguments. The court will take this matter under advisement. The court is now in recess until 10:30.